Welcome again. It is Monday, and we want to dive straight in with a discussion. Our colleague, Martin George, attorney at law, joins us, and we have a couple of things to get into. As always, Martin, great to see you. Happy Monday.
Yeah, hi. Good morning to you, JW, and good morning, Trinidad and Tobago.
Indeed. You know, while we were, at least the country, the narrative last week for most of the country for the last couple of days would have been the divers, there's a big story that went under the radar for many. Of course, those in the legal fraternity know exactly what's going on, and those who would have matters before the court or would have been impacted in some major way by the crime situation in the country would be on top of it. But many are not truly grasping this bail for all concept. I know the AG is trying his utmost best to push back on it, but the reality is, as of now, those who are inside, hardened criminals, those who have to, I guess, face the court, can apply for bail, and more than likely under the new umbrella here would get bail. Well, what say you concerning this development?
Well, I mean, Jason, at the end of the day, this is how the law grows and develops, by persons testing and pushing the boundaries and the limits of the law so that we get it expanded. You know, there are many things that in the past would have been deemed illegal or would have been prohibited. And, you know, I mean, like if you think of, you know, something as simple as women's voting rights, years gone by, you know, these are things that, you know, you had to test the limits of the law, test the boundaries, and that's how you had changes come about. And I mean, this is not just in Trinidad and Tobago, this is internationally also. When you think of a case such as Brown versus Board of Education in the US, which tested the segregation laws in terms of education of children, you know, this is how you get changes coming about, meaningful changes. As a result of that significant change, you had so many historic black colleges being founded. You had so many, you know, scholars of, you know, color who came about as a result of that opening up of the education system.
But Martin, but I trust that, you know, many who are victims will not really appreciate the history, because the reality is if someone, a loved one, would have been murdered, and here it is now, somebody who is in remand on said murder can now apply for bail, right, based on the Court of Appeal, right? It's been cleared now by the High Court. They could apply to the High Court for bail. I mean, this will not sit well, really and truly, with those people who are waiting for some semblance of justice.
I could very well agree, and I can very well understand, you know, their concerns, because it would be almost like you're letting these criminals, these animals back out onto the streets before you even have a trial. So I can definitely see where you would have that disconnect from, you know, the persons who have been the victims in the circumstances. But the reality, Jason, is that this is how our legal system functions. It's not by any means perfect. And anyone who tries to pretend otherwise is, you know, I mean, definitely given a false impression. And I'll tell you, you know, I mean, this will go to the Privy Council and we will hear what they have to say. But even the Privy Council, and I mean, this is just something I'll put out there for your viewers and listeners, Jason. Even the Privy Council, the only reason why the Privy Council is always right is because there's no higher court above the Privy Council. That's our final court of appeal. And the Privy Council itself has proven to give contradictory decisions. There are two cases which will, you know, really stark contrasts of each other. One is the Wagon Mound and the other is Repalimis. And different jurisdictions of the Privy Council gave completely opposite decisions on basically the same points in those two cases. So, I mean, even the Privy Council is not necessarily always right, but it's our final court of appeal, so we'll have to respect whatever decision comes down from them.
So I would imagine there is a window of opportunity for those behind bars, because until the application to the Privy Council is, well, it's made by early next week, we are seeing here attorneys representing murder accused, they are free right now to approach the High Court and apply for bail for their clients. So I would imagine the court would be busy this week.
Well, I would imagine so. And the fact is that the discretion is still there with the magistrates, with the judges, to determine whether to grant it or not. They are able to look at, you know, the scenario with whether you have other matters pending, what are your antecedents, what is the likelihood of you either absconding or fleeing the country. So all those things will be put into the mix. So it does not at all remove the fetter of the discretion of the judicial officers. In fact, that was actually the cornerstone upon which this case was argued. The fact that by saying outright that there's no bail for an offense such as murder, it served as a fetter on the authority and discretion of the judicial officer. And that's why the courts have ruled to say, well, look, yes, this should be revisited.
Martin, I'm going to switch gears really fast. I want to take you now to page 5 of today's Guardian. When you get a hold of it, you can check out the story. It says, opposition leader, she is taking issue with the appointment of energy expert Eugene Tia to be part of the probe team. This particular issue is based on the now Minister of Energy, Stuart Young, represented said Tia, Eugene Tia, back in 2014 for an e-tech court matter. Of course, Mr. Young, he is an attorney at law, and he would have represented, Eugene Tia in 2014. Do you see a conflict of interest here? Is the opposition leader within ground? Because I said this morning that once you are appointed to any kind of committee, I think that, any connection should be far and wide, as far as Point Fortin is to Toko. But the reality is, it's an island. Sometimes people intermingle
that's the reality.
Sometimes people intermingle. But do you see a particular, is there validity in the opposition leader's call?
Regretfully, I see none whatsoever. I see it as spurious, specious, and speculative, in the sense that the fact that you may have represented someone in a matter several years ago, that doesn't cast any blemish upon that person's integrity or professionalism and their ability to carry out their duties fairly and impartially. Because if that's the case and you were to do that, then you'd have to go back through every attorney's list of clients. I mean, the fact of the matter is, over the course of years, you would represent thousands of different people. That doesn't mean necessarily that if someone is appointed to a board or appointed to a committee that, you have some hold over them as an attorney, So, I mean, I would not at all want to go down that road. If it is that Mr. Tia has demonstrated in some way that he's somehow compromised, then that's a different thing. But in the absence of that, to simply raise that as a reason or basis to say that he ought to be automatically disqualified, I think it's really, clutching at straws, respectfully.
Yeah, and I guess that's why for many, there is that, I wouldn't say fear, but there is a hesitancy to serve, because the reality is any connection, any kind of communication, any representation between yourself and those who are in the corridors of power, whether it's on the opposition side or the government side, it will come to light, and more or less, they'll take your name through the mud, and it's one of those areas where people are truly, especially those who are probably well qualified and want to give back, they sometimes tend to stay out of the mix. I want to switch gears.
That's the point. I mean, it's a point that I think Dr. Terence Farrell has made repeatedly, because he has recognized that, look, it's so fraught with the backbiting and the movelang and the bacchanal that, really qualified professionals who are dedicated and consummate, in their field, they would tend to want to stay away from this.
Yeah. But I guess the opposition, they got their job to do it. They will do their research and try to find any kinks, I guess, in the armor and bring it forward. So, it's just, I guess that's politics at play. That's politics at play.
I accept that, yes, you have a job to do, but there's a way you can do the job which can earn the respect of the general population. And there's another way that you can do it where you just appear to be like, you see, like, sometimes you see like a patong chasing behind a car, yap, 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 barking at the car. When it catches the car, it doesn't know what to do with it. So then what's the point?
Yeah. I want to find out again, and I'm happy we're able to touch on a couple of different major stories. Right now, we recognize the suspension of the mandatory vaccination is definitely in the mix. I guess could be a combination of the pushback from the public. It could be a combination of the numbers dwindling. We're seeing a easing up of the restrictions. With that announcement was made last Friday. What say you in this particular regard, the suspension of mandatory vaccines?
Well, Jason, you know, I'm always very pointed, precise, and pellucid on these issues. And from the get-go, I made the point that the only way this can be successfully achieved would be if the government was willing to bite the bullet and go the distance of mandatory vaccination legislation. So in other words, I made the catchphrase, should we legislate to vaccinate? And I spoke repeatedly about that in the public spaces, on other television stations. I spoke about it, you know, on radio programs. So the fact of the matter is, without that legislative backing, this was a non-starter from the get-go. And that's why it boggled the mind. And it really was something that one could not fathom or understand as to why there would be an announcement in mid-December that this rollout is supposed to start somewhere around mid-January, and you knew you did not have the legislation in place. You didn't have the consultations with all the necessary stakeholders. You didn't get them on board. You didn't, you know, either buy the carrot or the stick. You know, I mean, so in other words, if they were not willing, then you would say, well, look, hey, I'm making it mandatory, I'm putting it into law, and we're going ahead with it. So there was none of that. And yet still you had the grandiose announcement, and then you had to do the climb down when mid-January reached, you know, because you clearly were not ready. So then the excuse was, well, the legislation isn't ready. But the point is, this is your program, and you knew that it required legislation. So it's not acceptable to then say that your legislation isn't ready. Then you give a further date of mid-February. Mid-February rolls around, we hear nothing until the very last minute, a weak and feeble excuse that, well, we're still working on the legislation, when by then, you know, it was basically a standing joke. Public servants were, I think, you know, thumbing their noses at the government at that point and saying, well, we know you're not going anywhere with this. And that's the fact. So it really was a case study in how not to plan an event and how not to roll out a vaccination program.
Martin, would you say this is a victory for the unions and the public servants who were against this mandatory vaccine, who said, you know what, you know the argument, my body, my choice? This is their victory?
Well, it could be looked at both ways. A victory for them and a loss for the country. Because when one looks at it on the greater scale of things, because I always like to look at the bigger picture, Jason, the country would benefit from greater vaccinations. That's proven scientific fact. There's no arguing about that. There's no debating that issue. So while they may want to look at it and treat it as their own Pyrrhic victory, it is really a loss for the country as a whole, in that we would have been able to move faster with the rollbacks of the restrictions, and we'd be able to open up the economy and, you know, get back to some semblance of normalcy much faster. But we'll have to see how it goes when the public servants are out to work today, and of course, when all school children are back out to school by term 3.
Thanks for that. Really quick before we wrap things up, what's your take, what's your personal take on that tragedy that took place with the divers, the 4 divers?
Well, you know, it appears to be error compounding upon error, compounding upon opportunism by certain persons who have, you know, sought to get their 5 seconds of fame in the midst of the personal tragedy that these families are facing. And while we love in such circumstances to point fingers and cast blame, I think what Trinidad and Tobago ought to use this as an opportunity for is to learn the lessons. Maybe out of this, we can create a proper code to govern such incidents. So therefore, there's an established standard operating procedure that we have, that everybody's aware hair off, because clearly something went wrong somewhere and the ball was dropped, but it just gets even more bizarre when I saw some report, I don't know if it's official, about a pathologist making some, really curious pronouncements on the matter. And, the thing is, we ought not to revel in the glory of the situation. We ought to be sober, mature, and respectful for the families and their moments of bereavement. And we ought to say, listen, let's find the answers, find the solutions, so that going forward, something like this will never happen again in Trinidad and Tobago.
You think the 45 days for the probe is a bit too long? Because that's definitely a call from those who question the probe. They're saying that, the ability to recall the incidents, people might change the story, things might become cloudy in somebody's mind, the ability to recall it as it happened. Is that 45-day period a bit too long? You think this should be one that should be wrapped up in quicker time?
It does seem to be an extended period, and it might be a deliberate time frame set, because it's said that in Trinidad and Tobago everything is a 9-day wonder. So maybe the hope may be that by time that is finished, that it's no longer a burning issue for the public, but it will always be a burning issue for the families, friends, of the loved ones of those who passed away. So it will always be a burning issue for them.
Indeed. As always, I want to thank you for the perspective, for giving us some insight. Always good to pick your mind and just really find out what's going on. But I take it back really to the point you made, again, about service, those stepping up in terms of that issue with Eugene Tia. Because in my opening, I would have said that I know once there is any kind of connection, communication, it seems like that will always be used against you. But when we consider Trinidad and Tobago, it's truly small, and chances are we will bounce up, we will meet up, we will transact business. But in the realm of politics, once there is that connection, by all means, those who are against your particular mandate would do due diligence and raise the red flag. And now Mr. Eugene at home sipping his tea and his name is calling up.
Yes, that's the unfortunate reality. You see, Jason, if it were that they were in business together, business partners, or I could understand something like that. Well, the fact that you would have represented me, and then it may even have been through the company that may have hired you to represent me, as opposed to me personally going and hire you, and it doesn't necessarily mean that we are friends. Not because you are someone's attorney means that that person is your friend. That's a client. And you also, as the attorney, have a duty of confidentiality and impartiality in dealing with the person's matter. So I would not necessarily say that by itself disqualifies Eugene from sitting on the board. If it is that there's more that is revealed to show that there's something that can really create a conflict, a genuine conflict of interest, then of course, I think he would be the first to step aside. But really, just to simply say because of the fact of having represented him some years ago, I'm not sure that's sufficient, respectfully.
Martin, all the best. Thanks again for the candor, and we will touch base soon.
Always a pleasure.
Yes, Martin George, attorney at law. Always a great guest chair on The Morning Brew. We come back, email handles, social media information, something to think about, and the ever-popular birthday brew. Stick around.